What happens if your employer misses the arbitration hearing? My name is Nonkululeko Mbele. Welcome to my channel. In the event that your employer misses the arbitration hearing, the arbitrator can continue with the arbitration hearing without the employer being there, unless if the arbitrator has acceptable reasons for the absence of the employer. The unfortunate part about this is that the arbitrator will only be able to scrutinize the evidence that's in front of them, and this can result in a default judgment. What happens when you get a default judgment? What the employer can do is apply for rescission, and good people be advised that this is a very delicate process to be done. So I advise that you get an expert to help you in this regard, because there are strict deadlines to this application. The rescission application is made against the same arbitrator that made the default judgment, and this application will only be granted if it is properly put together and all the necessary information is included. What is going to be argued in this application will be the reasons for the absence of the employer and whether or not he or she has chances of winning this case. If it happens that this rescission application is denied, what the employer can then do is refer the matter to the labor court for review. What will happen when this matter has now been taken to the court? The court will be asked to put the default judgment and the application for rescission aside, based on the fact that either the arbitrator has committed misconduct in relation to the proceedings, he or she has committed gross irregularity in the procession of the arbitration hearing, he or she has exceeded their powers, and lastly, that the award was done improperly. Good people, I just want to advise against this, based on the fact that if ever it happens that this matter is referred to the labor court, firstly, you may not win. Secondly, taking a matter or referring a matter for review is quite an expensive exercise. And lastly, if it happens that you lose this case, you are likely to pay the fees of the employee. Good people, let us avoid reaching to this moment, and let's try by all means not to refer cases to the labor court. Till we meet again next time, goodbye.